Howdy, and welcome to another episode of Cooper's Code Lifecycle of a Case series, where we provide tools and tactics for the different phases of a case. We're compiling all of these episodes into a playlist on our YouTube channel, so head on over there if you want to see them all. Our third section is pre-litigation. That's where we do our best document assembly, getting a lot of that information early on to the insurance company and being open and transparent with the insurance company about what this case involves so that they can help get a better sense of things. On the collectability side, we send over a letter of representation. It has an injury bullet point. It will immediately demand the defendant's insurance policy limits. We typically will do a full demand package to send over to the defense adjuster before we file suit. That's the opportunity to file the complaint and make sure that the other side is actually formally brought into a lawsuit and into litigation. The next phase in terms of discovery, I'd considered putting before filing suit. Why did I consider that? I considered doing it because one of the things we strive to do at the firm is to have our proactive discovery drafted before we file suit. Why do we do that? Because we will oftentimes hand serve our discovery on the defendant in as short a window after we've filed the complaint as possible. And we do that for a couple of reasons. One is the defense almost always will serve their answer with a big pile of discovery and a deposition notice, and they will claim that they get preference because they sent their deposition notice out first. So that's one reason. It allows us to get our notices of depo, our request for reduction, our request for admission, our interrogatories, our person most knowledgeable depositions. All of those get sent out so that we can claim preference. And it also sends a further message, which is this firm is on their toes. They are going to be pushing this litigation, not reacting to this litigation. And that's the way plaintiffs' lawyers want to be as they're going through a case. On the discovery front, there are a number of different tools. There are interrogatories. Interrogatories are formal questions, the most common being form interrogatories. The form interrogatories are just simple checkboxes, and you get a bunch of data about the other side. There are also special interrogatories. These are subject in California to the rule of 35, which means you can only ask 35 special interrogatories, without doing a declaration for additional discovery saying why this case is unique or special or different and why it should have more than 35. I will say, while lots of people do contention interrogatories and other special interrogatories, I find a lot of the written discovery, short of document production, a lot of the written discovery is an area where defense can bill a ton, and it otherwise is time-consuming and not particularly illustrative for the plaintiff. So I am not a huge proponent of special interrogatories. I do love requests for production. I do love requests for admission. Now, the requests for admission also are subject to the rule of 35, meaning you can only do 35 without a declaration for additional discovery. When you serve them with form interrogatories, there's a little box 17.1 that you can check, which is if the answer to any of these requests for admissions served with this form interrogatory set is anything other than admit, then you have to provide a bunch of information in response to all of these. So RFAs are a great tool to, in essence, get what you need from special interrogatories, where you admit that you were liable for this collision, admit that you were negligent in causing this collision, admit that our client was not comparatively negligent. I understand that the language is very loose. It would be more specific in an RFA. But these general areas can be very, very helpful because you'll usually get denials. When they deny it, they have to provide a bunch of information to explain why they deny it. If you prevail at trial over things that they should have admitted, then one is entitled to request for admission sanctions. What that means is you're entitled to the attorney's fees for the time that you needed to prove these facts and for the additional costs that you needed to prove these facts. So this is a great way in what should be a clear liability case where they deny it to get further compensation at the end of the trial for all of the unnecessary time you had to put into proving that they were liable in the case. So we generally use the RFAs to tamp down and try and clarify the issues and then set a marker to be able to beat when we go to trial and prove that they were in fact liable for the collision. Requests for production are all the documents that you have not already been able to get in any other way throughout the course of the case. So we usually will demand the full policy language of insurance policies, and we do it across the board. Why do I do that? Even in cases where the insurance policy should not be of interest, we always learn from our examples, past mistakes. I had a case years ago that seemed like a straightforward industrial incident. I had a guy whose leg got taken off in a rice dryer. The facility had been routinely inspected under contract by a safety company, and we demanded the safety company's $1 million policy under 998 because it had been disclosed that it was a $1 million policy. Well, when we later on in the case are fighting over things, we are told that that was a diminishing limits policy, meaning while it was $1 million to start, the cost of defense got eaten from the policy. So at the time that we had made our 998, it was not $1 million. There was only $992,000 available. Therefore, our 998 wasn't valid. Now, a lot of technical arguments about why that was or was not accurate. Ultimately, things ended up working out well in that case. But the learning for me was, even when I think the insurance policy is a straightforward policy, we want to see the policy language. So we demand the insurance policy. And then, depending on the case, most firms will have what I would consider to be templated for these types of categories of documents in these types of cases. You want to make sure that you can gather pretty much everything under the sun that you think might be used against you and that you might be able to benefit from in the case. Unfortunately, discovery is an area where the defense has learned from state courts that it benefits from hiding the ball initially. Does this happen with every defense counsel or every defendant? It does not. However, a common tactic is to provide crappy responses and a handful of documents in response to a request for production. And it then becomes a battle of meeting and conferring, demanding more, and moving to compel. I've talked to some defense lawyers who will say that their client, and I want to be clear who and how I'm talking about people. Defense lawyers aren't always the ones who are doing things that we sometimes infer as bad behavior. Oftentimes they're doing it at the client's direction. And there are some defendants who just, their stock in trade, particularly in product cases, is we don't give any documents, not anything meaningful, until we get the first motion to compel. And the learning there is part of the work in the more complex cases, products, harder things, is you aren't going to get stuff until you move to compel. The reason this exists, by the way, not surprisingly, it's much rarer in federal court. It's rare in federal court because federal judges will sanction the ever-living shit out of you when they feel that the games are being played. But in state court, the sanctions tend to be fairly minimal. It's a rounding error for most defendants. So why not make it really hard? Why not see if this particular plaintiff's lawyer is going to do their work for their client? And why not just keep pushing back with the hopes that somebody's going to be lazy on the other side? So it's not the way things are supposed to be done, but it is the way things that happen. If you get into litigation and you're dealing with defendants who are challenging you got to do your job. That involves doing the hard work of moving to compel. A side note, there are oftentimes creative ways to get the same information. We talked a little bit about Public Records Act requests and about Freedom of Information Act requests. I'll use an example of being creative. We had a construction company that was shining us on about getting the contract and subcontract for a major construction project. As we thought through it, we recognized that the construction contract was for an expansion, and the subcontractor contract was for an expansion at the San Francisco International Airport. What that meant was we don't need to get it from them. We can get it from the city and county of San Francisco. So not only were we able to get the contract with the general, we were able to get the contract between the general and the sub because they'd had to submit that as part of the package to the city. So we got that through a PRA where the defense has no idea that we have it. And then we start asking questions at a PMK deposition with it. And the defense counsel is caught a little bit with their pants down in terms of preparing their witness because they had no idea that we were able to get the things that they were hiding from us. So when you think you're being shined on, just think about other creative ways to get the same information. As far as depositions are concerned, there are a variety of thoughts on how to take depositions and how to structure depositions. A few comments from my perspective in terms of depositions. This part is not controversial at all. We like to do all of our written discovery well before we take depositions. We're going to take the best depositions possible, particularly of what are known as persons most knowledgeable or persons most qualified or designated agents, whatever you want to call them. We'll take the best depos of those people when we have the documents about policies, procedures, protocols, the incident, investigations, etc. So getting ready for those depos involves getting all of that material packaged so that one can ask coherent questions related to them. There may be strategy involved in terms of who goes first. Do you want to take the fact witnesses before you take a designated agent? That's one area where it's not always ironclad that you want to do it one way or another. Another thing that comes up that different people have different approaches to is that there will be individuals who oftentimes will have their own personal knowledge, and there will be a person most knowledgeable. So you might have John Doe. John Doe is the project manager who was on site at the time that Peter Plaintiff got hurt. He was the one who responded to the incident. He documented the incident. So John Doe, the construction manager, is going to have personal knowledge. He is also the project manager and will be the designated agent. A lot of times you'll get the defense who will say, well, we're going to produce him. We'd like you to take just one deposition and with that one deposition, cover all the facts in his individual capacity and also as the person who's most knowledgeable. There are people who prefer to take those as two, and there can be a benefit to that. One can be, it gives you time to go back, take a second depo and be more, if you've forgotten anything, or as you review it, it simulates questions to ask or further discovery to do. That can be beneficial in that regard. There's a flip side benefit of taking them together. And the flip side benefit is sometimes you will have people who will be cleverer in terms of saying, well, this is something I did in my individual capacity, but not on behalf of the company. And if you want the testimony of that person to bind the company in all things, it can be helpful to have both of those depositions, fact and PMK, in the same depo. And the admonition that goes along with this is, Mr. Doe, you're being produced here both in your individual capacity and as a PMK. The way I'm going to proceed with this is I'm going to presume that anything that you're testifying to is as a PMK unless you tell me to the contrary, that, for this one thing here that I'm testifying about, that's in my individual capacity. And then Mr. Doe forgets the admonition, goes through the entire deposition, and everything that Mr. Doe says is a binding act as the PMK for the defendant. So again, different ways to approach the depositions. Also within the frame of what I would call discovery is summary judgment. And I say it's within the frame of discoveries because at some point during the case, usually in the discovery phase, meaning before expert disclosure, before trial, there are cases where the defense will seek to move for summary judgment. There are pros and cons related to summary judgment. One of the pros is that nothing gets one ready for trial the way summary judgment does. It forces one to dig into the case. It forces one to be proactive in taking depositions well before the eve of trial or expert disclosure. It's a wonderful opportunity to really dig in. It's also exceedingly time consuming, but I think of it as a gift when the defense sends us a motion for summary judgment. So when one arrives, recognize it for what it is, which is a way to hold your feet to the fire and to double down on your diligence in terms of being ready for trial.
Thank you for tuning in. If you enjoyed this, check out our previous episodes. More will be coming soon. If you're enjoying what we're doing here with Cooper's Code, please help us extend our reach by giving us a 5-star review on Apple Podcasts and consider sharing an episode with a friend. Please email us at podcast@coopers.law with questions, comments, feedback, and suggestions you have for who you'd like to see on the show. To all of you doing justice out there, happy hunting.